It just does not end with getting a work permit. If the employer is not in compliance with the offer of employment submitted with ESDC and IRCC, then it becomes a big problem for them.
Hello, and welcome back to another episode of Law and Order, the Canadian Workplace Edition. Today, we're going to be exploring everything about remote work, foreign employees who work in Canada and cross border. And we're going to start with the first question that is directed towards Leona. Leona, the first question that we have is: how are employee disciplinary issues handled in Canada?
Thank you. It's a great question. It really depends on whether or not the employer is unionized or non unionized. In a unionized setting, disciplinary action, that process will be covered by the collective agreement. So individuals should refer to that if they have any questions. In the non unionized sector, which is actually most of Canada, it's really going to be determined by the employer. Best practice is that there be a documented policy. That typically is not the case for a smaller employer, though, in my experience. But generally, the progression of activities is if something is being done or not done that needs to be addressed with an employee, the first piece is going to be a conversation with the individual to advise, to correct, to train, to determine is there some sort of a barrier that's there. And then from there, it will go to a written documentation. From there, it can sometimes go to a suspension. It needs to be a documented policy, and there needs to be something in the employment agreements, or else it could be constructive dismissal if you just suspend somebody without there being any kind of documented policy to it. Final piece to it all would be termination. So that's generally the sequence. It is considered to be progressive. The idea behind it is that we give people time to determine what it is that they're doing or not doing, and give them time to correct it and then move it forward. So it's really meant to be a problem solving process rather than something punitive. However, it's often exercised as a punitive activity, which is a little bit unfortunate.
This is an excellent overview, Leona, because from our immigration standpoint, and also which includes employer compliance, our core document comes from the employment agreement. What were the terms and conditions of the employee when they were hired? And that actually leads then ultimately to, are there any compliance issues that the employer should be careful about? And then ultimately to the punitive damages, or however it plays out. But to begin, I would emphasize that for an employer, having an employer agreement laid out very clearly, which puts out the conditions of the employment, the working conditions, the job responsibilities, and what are the expectations, what are the wages, salary, and vacation. All those nitty gritties has to be dealt right on day one. We also emphasize that the employer should be actually handing out the handbook of the company, where it lays down what are the expectations of the employee or the employer from the employee. So those conditions, once it's communicated clearly right from day one, would actually save the employer from all the hassle, save the employer from going forward with all these or all the disciplinary actions that could ultimately lead to inefficiency on the part of employee or other possible conditions. But then this could all be mitigated if we are communicating, or the employer is communicating right very clearly in the beginning of the process.
Awesome. With that, let's move forward to our next question. And directed towards Leona would be: what are the employer's obligations around disciplinary actions?
It's a great question. Before we start the disciplinary process, we really need to have some idea of what really were the expectations. What were the expectations that were set up? What was in the agreement? Even to go so far as if it is somebody who's relatively new to the team, how did we actually hire the person? Were we clear in the job description as to what the responsibilities were going to be? How did we ask questions to really ascertain that the individual is capable? Sometimes an individual is not honest during an interview, it happens, but the focus from the employer is to really start and say, well, did they know? And how are we supporting them in that regard? So some of the questions that we ask ourselves, as you know, from an HR perspective, are the expectations known? Do they have the tools that they need to do the job? In other words, do they have access to software? Do they have access to training? Has there been any kind of mentoring? Are there any documented processes or procedures that the person could follow? In most cases, that's pretty spotty. It doesn't really exist very well. If that's not the case, has the individual had the opportunity to work with somebody who could actually show them what to do and to answer their questions? Are they encouraged to take notes? Because it's also the responsibility of the employee to learn and to try and make sure that they're keeping up with everything. There are some other issues that happen. When we go to sit down with the individual, we also need to ask them what happened on their side. We need to say, here's what we expected, here's what's happened, what's your side of it? There might be something there that we are not aware of. And should never go into a meeting having already made up our minds that the person has done something wrong. It's meant to be an exploration. We have always those principles running in the background of fairness and proportionality, in terms of how we go through the inquiry process. From the employer side, we need to make sure, do we have the same expectations for everybody on the team? Now, obviously, we would expect a higher rate of errors from somebody who's just joined the team than from somebody who has been with us for a long time. This is part of the inquiry process. But it shouldn't be that, because somebody is just there on a temporary basis, that we expect them to do three times as much as somebody else who's been there on a regular basis. So that concept of fairness, and if somebody else did or didn't do the same thing, would we handle it in the same way? That's really important, because it's not just around Employment Standards Act that we're concerned about, but we're also concerned around human rights. And are we being fair to people? The other side to it all is when we ask the person what happened, if there is some sort of an issue that's going on for the individual, or something that they have not disclosed thus far that maybe has an impact for the need for accommodation, this is the opportunity for the employee to share that with us. We are not allowed to ask people, is there something we should know about your health? It's not our concern. But we have to allow for the conversation to transpire so that if there is something that the employee can disclose, and sometimes it could be something like, oh, you know what, I'm going through a divorce. So you understand the person is under high stress. Maybe we need to lay off a little bit and, provide some additional support through an EAP program, an employee assistance program, if we have it available through our benefits, or we just need to provide a little bit of empathy to the individual. The standards are the standards, the rules are the rules, but we can be a little bit flexible if an individual is in a situation where maybe things are a little bit much for them and we know that it's temporary and it's going to come back and we're going to work our way through it. So that is the concept of fairness. And the other piece is, if we're asking for some changes to be made, we also have to allow for enough time for that change to be implemented. We can't say to somebody, okay, we need you to do this, 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 and this, and then the next time expect that it's going to be done perfectly. We have to allow for a little bit of a learning curve and a little bit of an adjustment curve. Depends on the complexity of the role. In most cases, 3 to 5 days is considered to be reasonable, but it depends on what it is.
This is again excellent, Leona, how you've laid it out from the HR standpoint. And human resource are always the one who are going through the most difficult and challenging questions, where it's their responsibility to make sure that the employee is following the orders or following the marching orders that the employer laid out right in the beginning. From the immigration standpoint, from the employer compliance standpoint, we rely heavily on immigration regulations, which is Immigration and Refugee Protection Regulations, and Section 209.2 subsection 1 subsection A. It lays down the conditions regulations of the employer. Where the employer compliance becomes an issue, that's where we get our references from these regulations, and also the ministerial instructions from time and here and there where there are updates or amendments, etc. But coming back again, the employment agreement or the employer compliance, the company handbook, these are the regulations that dictates the terms and conditions of the employment right from the beginning to the end. And if they are not in compliance, I highly suggest my clients, my employers, to have a mock audits, to go through the HR files for each employee time to time and see did they provide something as basic as know your rights, which was implemented in September 2022. Is there know your rights? Have you put that somewhere in your easily accessible place such as the kitchen area? You should be having all this available not just for the Canadian citizens, permanent residents, but of course most importantly for foreign workers. This should be readily available for them to understand their rights, to make sure that they are in terms and they are meeting the requirements. And fast forward, if we say that there has been any breach from the employees in performing their job responsibilities, it of course those little meetings become very, very critical during the progress or during the employment of the foreign worker, citizen, permanent resident, however their immigration status is. Those meetings has to be documented. It has to be clearly put in the HR folder, and these such kind of folders, as to the best of my understanding, has to be maintained for at least 6 years during the course the employee is working with the employer. So those are important things that the employer should consider and should make sure that they are in compliance with all the requirements, which could be from the province, which could be from the federal law, which is ESDC, or even IRCC. They have to remain in compliance. It's a competitive world. There are complexities related to laws, and just staying right on top is always the best plan.
I think that was incredibly insightful, especially since on both ends, whether you're an employer or an employee, this becomes information that most people don't generally think about or look into or are able to understand. And that brings me to my next question. What type of record keeping or reporting is expected of an employer?
Thank you. The record keeping is so important. And I'm going to say from my practice working with smaller employers, even larger employers, this is one of the big areas that needs improvement. In that, if there is an issue around performance, so often the manager will have a conversation with the employee, but they don't document that they had a conversation with the employee. And sometimes comes to me, well, we've been talking to them for 2 years. Well, but there's no record of it. So if there's no record of it, it doesn't exist. And this, well, it's a conversation. Well, even though it's a verbal conversation, you should still take some notes because that would actually demonstrate down the road that you actually did address the issue and what was going on. I even provide a little form for my clients to use if they're having a verbal conversation with an individual, just to help to guide them through the process and make sure that they're offering out accommodation as well if it's necessary, because this is important under our human rights and under AODA. But by and large, the note should be around what the issue was. If there are emails or if there's any other kind of text messages or anything like that, that should be kept. That should be memorialized in case it's needed later on down the road. There should be some notes around what the employee had said or what the commitments were. The idea behind this, and again, it comes back to what I was mentioning earlier on around the issue of fairness, procedural fairness. You want to make sure that it's been addressed in a reasonable way, that we have not all of a sudden held somebody accountable to something that they never heard about, that they didn't know about, that they had no way of actually fulfilling on because they weren't training. So the note keeping becomes important of what that conversation is. And sometimes even in a verbal conversation, I would suggest the individual could send an email to the person afterwards and say, I just want to confirm the conversation we had today. We had talked about this and this. You had mentioned this and this. We're going to get together again next week and see how it's going. that can be enough. And that puts the onus on the other individual to come back and say, well, no, that's not the conversation we had. I don't remember that or whatever. But at least it starts the process forward so that there's something to work with. As far as reporting that would be expected, by and large, there aren't a lot of reporting requirements for the employer, but it's very contextual. It really depends on what the situation is, and it depends on the industry. So, for instance, if there is a complaint that comes to us around potential theft, and we do our own little investigation and we determine, okay, it does look like there is a theft, not all employers will necessarily report that to the police, but there are certain things that definitely will get reported to the police. That would be, in particular, violence, sexual violence. If it looked like there was some kind of embezzlement or some major theft, these things would be reported to the police. And of course, I cannot say for sure what the responsibilities are to report that further on in the case of somebody who is on a work permit, but I'm hoping Gagan can fill us in on that piece.
Yeah, absolutely. Yes, this is such a critical piece of the entire immigration process. It just does not end with getting a work permit, but the employer compliance becomes so critical that if the employer is not in compliance with the offer of employment that they have submitted with ESDC and along with IRCC, then it becomes a big problem for them. They could be liable for a fine which is from few hundred to up to $1 million. So we just don't want that kind of, and besides they also get blacklisted on the website. So we just don't want that this condition should ever come up, and especially if the employer is a small employer who is just setting up the company and will not know about these nitty gritties. It's not about that they deliberately breach the law, but it is sometimes that the employer is just not aware that these laws exist and what are their responsibilities. So in what you've indicated, Leona, is absolutely great, where you have mentioned that yes, keeping those notes are so critical during the entire time the employee is being hired, and keeping those notes just makes it very clear. At the end, anybody, the court want to see communication. Did you provide clear communication to the employee about the terms and conditions, about what are the expectations? It becomes all the more critical when we are talking about work permit holders who are hired based on the LMIA. You've hired an employee as an accountant. You cannot be having the employee taking a very different role from what you've hired. Then you are totally in breach of the terms and conditions of the hiring process of the LMIA, which is a very serious offense. And if in case of an audit, the ESDC would clearly ask you what were the terms of conditions. Have you informed that there were changes in the terms and conditions of your employment, and so on and so forth. So, and at that point, the regulations come in play. At that point, the ministerial instructions come in play. At that point, the employment agreement for which the employer paid $230 compliance fee right in the beginning, that comes in play, and it could be of serious consequences if it's not dealt right in the beginning of the process. So I agree, Leona, that it's a lot. As much as we feel that it could be few files here and there, the work permit is on file and we don't worry about anything else. That's really not the case. There's so much that goes on, and it just becomes so critical for each one of the players who are involved in this entire process to be right up on top of it.
So I have a question for you, Gagan. I've heard sometimes that there are some employers who will potentially threaten to report their employees to IRCC. How does that play out?
That's not a good situation at all, Leona. If an employer is using threat, caution, etc. on the employee and taking the advantage and benefit of their situation, that's not a good situation, and it may play out against the employer. See, the employee will have a bit of benefit out here because they are settling in a new job, and especially if they've been hired under an LMIA program, then they are still settling with the employer. But If there are breach of conditions, for example, I've come through where there's a breach of condition with the work environment, with the wages, and I've also come across certain situations where the employee has not been paid what they were promised. Those are really, I would say, ugly situations, and employer compliance has to be right on top. You don't, as an employer, want to be in a situation where you are blacklisted, and if you are using this kind of a caution and it's been documented by the employee in some way, has been recorded or saved in the emails, texts, etc., you don't want to run into that situation at all, because the worst that could happen will be that the employer would be barred forever in hiring any foreign worker, and there could be other serious consequences as well. So it's always to be on the right side of the law. And I'm a very conservative lawyer. I always ask them that, okay, if you went on the wrong direction by mistake, fix the mistake, or take the ownership of your mistakes and fix it, so that at the end it should not even matter to the employer, neither to the employee. All right. Do you have, Leona, do you have anything to summarize and tell our listeners at the end how they should be playing out with their HR folders?
Exactly. So I think the responsibility is there for the employee as well to make sure that they know what is expected of them and to be an active participant in the process. If there is a conversation or if there is a letter that's coming through, they too should take some responsibility and they should take some notes, particularly in some of the examples that you just provided, where an individual is maybe not being paid the way they are supposed to be paid. Quite often, the individual will go and will ask the employer and say, well, what happened? I think it's important for the employee as well to document that in some way, to send a text message or of the conversation, or maybe just to send an email and say, hey, I've just looked at my pay stub. I worked 40 hours. I didn't get paid for 40 hours, just so that they have a record that's there as well, because our employees are protected from retribution for acting out on what is actually their entitlements. So I think the note keeping piece and the acting in good faith and working in a good partnership scenario is the best. And hopefully, none of our viewers ever have situations where they run into the darker side of this process.
I so much agree with you, and I would say the same thing to the employers that if there are any doubts, there are helplines available with ESDC. There are provincial helplines. There are so much information out there on the government websites that if in doubt, call them, call professionals, and take the right call before you run into any difficult situation which you don't want to be. So, best is reach out to the government authorities or to the professionals and get that act cleared up so that it just goes very well for both the employer and employees.
Thank you so much, Gagan and Leona, for another very exciting episode. And to all our viewers, if you want to see more deep dives into the cross section of immigration and HR, do give us a follow and subscribe and keep watching. Thank you so much.